So good day, I am Toledo Giancarlo A from BSc 3-3, and my report is all about comparing the alternative dispute resolution of Philippines and Singapore. So before we start, tumungo tayo at dami ng presensya ng Panginoon sa ngalan ng Ama, ng Anak, ng Espiritu Santo. Amen. Panginoon, maraming salamat sa araw na ito na binigay mo sa amin. Panginoon, bigyan mo ako ng kalakasan at sapat na karunungan para maibahagi ang mga impormasyon na kailangan nilang matutunan para sa report na to. At sana ang mga klase ko rin ay merong sapat na karunungan para intindihin at maintindihan ang mga sasabihin ko sa video ito. At salamat sa lahat ng biyaya at patuloy mo kaming ingatan. Ito ang aming salamat dalangin sa matamis na pangalan ng iyong anak na si Jesus. Amen. So, before we compare yung alternative dispute resolution ng Philippines at Singapore, alamin muna natin kung ano yung ibig sabihin ng alternative dispute resolution or yung ADR. ADR refers to an array of methods for resolving legal disputes without resorting to the court system. ADR aims to provide a quicker, cost-effective, and less adversarial means of resolving conflicts. So, sabi dito, ADR is yung mga methods or process para ma-resolve yung mga disputes or arguments ng dalawang tao na hindi na dumating pa dun sa court. Kung di na dadating sa court, kung mareresolve na agad siya sa labas, so ang magiging epekto nito is mas mapapabilis niya yung pagresolba nung dispute. Less na din dito yung gastusin sa mga babayaran para dun sa mga court trials, ganyan, na papatagalin na tapos gastos ka pa. So dito sa ADR, less na yung gastos, mabilis pa yung process ng pagresolve ng conflicts. So, Philippine Alternative Dispute Resolution is on RA Republic Act number 9285. This act shall be known as the Alternative Dispute Resolution Act of 2004. So, ADR system means any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge or of a court or an officer of a government agency as defined in this act, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early mutual evaluation, mini trial, or any combination thereof. So, based sa RA 9285 ng ating batas, ADR, same lang din talaga siya ng yung meaning, yun lang din talaga. So, ito yung mga process or mga methods na ginagamit para ma-resolve yung mga disputes or controversy, arguments ng dalawang tao or dalawang party or pwedeng company, ganyan, na hindi na kailangan ng judge or hindi na kailangan pumunta sa court or kahit anong government agency. So, dito, kumuha tayo ng isang neutral third party para masolusyonan yung mga issues. So, kung sa Philippines ay ganun, let's go to Singapore Alternative Dispute Resolution. So, for Singapore, ADR refers to methods for resolving disputes without going through formal court litigation. ADR typically includes processes such as mediation, arbitration, and conciliation. Singapore has become a prominent hub for ADR in Asia, especially in international arbitration due to its legal framework and reputation for efficiency and fairness. So, same lang din ng Philippines, ng ADR sa Pilipinas, na ang kanilang aim is to resolve disputes without going to formal court litigation. So, inaayos nila yung disputes or yung arguments, controversies sa labas pa lang. So hindi na nila papahabain pa kumbaga yung yung mga issues. So dito sa ang pinagkaiba lang, isa sa mga pinagkaiba rin siguro ay isa rin sa mga pinagkaiba yung ano lang, kung ano yung mga forms or types ng ginagamit sa sa dalawang bansa. So, para malaman natin kung ano yung mga pinagkaiba, here are the types of ADR in the Philippines. So, number 1 is arbitration. Arbitration means a voluntary dispute resolution process in which one or more arbitrators are appointed in accordance with an agreement of the parties or rules promulgated pursuant to RA 9285. Resolve an issue by rendering an award. So, pag sinabi natin arbitration is yung pag merong isang arbitrator, isa or dalawang arbitrator na naka-appoint sa isang dispute, sa isang case, kumbaga, naka-appoint sila para magbigay ng decision dun sa dispute na nangyayari. So, sa arbitration, sila yung magde-decide, yung arbitrator ang magde-decide kung ano yung kailangan nilang, ano yung solusyon na gagawin nila dun sa dispute. So, number 2 naman is mediation. Mediation means a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assist the parties in reaching a voluntary agreement regarding a dispute. Settlement is made by the parties themselves. Third party cannot make a proposal. So, sa mediation, meron tayong tinatawag na mediator. Mediator is a person who attempts to make people involved in a conflict come to an agreement and go between. So, sa mediation, yung mediator, hindi siya tulad ng arbitration na sila yung magde-decide. Sa mediation, yung mediator ang magko-communicate sa dalawa para magkaroon sila ng negotiation, ng agreement para matapos na yung issue. Dito sa mediation, hindi pwedeng magbigay sila ng proposal in third party. Hindi sila pwedeng magbigay ng proposal. So, sila lang yung mag-aayos, kumbaga sila yung pagbabatiin nila yung dalawang parties para mag-come up sila sa isang negotiation na ganito yung gagawin natin para okay na. Kumbaga same, bibigyan mo sila ng tig-isa silang kailangan gawin para matapos na yung issue. So for number 3, conciliation involves the assistance of a neutral third party who plays an advisory role in reaching an agreement. Third parties can make proposals. So conciliation is also known as mediation. Pero this time, pwede magbigay ng proposal yung third party. Ito naman sa pang-apat is mediation arbitration. It is a step dispute resolution process involving both mediation and arbitration. So, ando na naman siya sa pinaka pangalan nung kung ano yung type na yon. Kasi kung nasa mediation arbitration, so pwede combination siya ng dalawang ADR type. Number 5 naman is early neutral evaluation. So it is an ADR process wherein parties and their lawyers are brought together early in pre-trial phase to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the subject and the substance of a dispute. So for number 5 naman, dito naman may mga lawyers ang both parties. So may tinatawag silang pre-trial phase para i-present yung mga summaries nung cases. Then a experienced neutral person, yun yung mag-aayos or titignan kung ano yung dapat nilang gawin dun sa dispute. Number 6 is mini trial. Mini trial means a structured dispute resolution method in which the merits of a case are argued before a panel composed of senior decision makers with or without the presence of neutral third person, before which the parties seeks negotiated settlement. So, for mini trial, ito ay isang alternative dispute resolution na may attorneys on each side para dun sa case. Parang actual na may trial, pero hindi siya totally yung katulad sa trial sa court. So, number 7 naman is court annex mediation. It's a mediation process conducted under auspices of the court. Auspice of the court after such court has acquired jurisdiction of the dispute, referring the parties to the Philippine Mediation Center or PMC unit for the settlement of their dispute, assisted by a mediator accredited by the Supreme Court. The agreement reached is considered legally binding by the court. While the process is mandatory for selected cases, the parties are not forced to reach settlement. So for court annex mediation is conducted under the auspice of the court in the pre-trial stage of case, giving the parties an opportunity to explore whether the dispute can be settled amicably before going to court. So dito sa court annex mediation, may pre-trial stage. So may opportunity para ma-explore muna yung dispute kung pwede ba siyang i-settled amicably or bago siya pumunta sa court. So sa types of ADR in Singapore, number 1 is arbitration. So ganoon pa rin, arbitration involves appointing arbitrator na specialized yung knowledge sa mga ganyang field. Kunyari sa business, mga business field. So sila yung naatasan para mag-decide kung ano yung dapat mangyari or dapat gawin ng both parties, or sino may pagkakamali para maayos yung issue. So number 2, kagaya rin ng sa Philippines, mediation. Kailangan nila ng mediator para maayos yung negotiation, para mag-come up tayo sa negotiation para matapos yung issue. Dapat mag-arrive sila sa mutual or parehas na acceptable resolution. Number 3 naman is neutral evaluation. It involves appointing a neutral party to assess the dispute, helping the parties better understand the strengths and weaknesses of their respective cases. Select a third party to assess the issue so that the parties can better grasp the advantages and disadvantages of their respective positions. So parang katulad din siya ng mediation. May neutral party na mag-assess ng dispute para maintindihan nila yung mga kalakasan at kahinaan ng kanilang mga dun sa cases nila. So sila yung mag-assess ng issue in third parties para malaman nila yung advantages and disadvantages ng kanilang respective positions. For number 4 naman is neutral determination. It involves appointing a neutral party to make a temporary decision on the dispute. If either party is dissatisfied with the decision, they can apply to an arbitrator or a court for a new determination. Choose someone to decide the dispute temporarily. If either party is unhappy with that decision, he can apply to an arbitrator or a court for a fresh decision. So sa neutral determination naman, may yung kukuhain nilang neutral party is magde-decide dun sa dispute. Sila magde-decide Kung hindi satisfied both parties, pwede sila mag-apply sa isang arbitrator or a court for a new determination. So, ang atin next naman is ang comparison ng Philippine ADR and Singapore ADR. So, for legal framework, Philippines is naka-base sa RA 9285. Ang Singapore naman is sa Singapore Mediation Center or SMC, which is appointed by IMDA. So naman doon naman sa office, ang Philippines ay may OADR, which is established under RA 9285 or the Alternative Dispute Resolution Act of 2004. Sa Singapore naman, the Office of Singapore ADR refers to institutions like Singapore International Arbitration Center or SIAC, Singapore Mediation Center or SMC, and Singapore International Mediation Center or SIMC. Para naman sa organizations, meron tayong sa Pilipinas ay meron tayong 5, which is yung OADR or Office for Alternative Dispute Resolution, Barangay Justice System or lupong tagapamayapa. Pangatlo is yung Philippine Dispute Resolution Center Corporation or PDRCI. Pang-apat is Mediation Center of the Integrated Bar of the Philippines or IBP. And lastly is yung National Conciliation and Mediation Board or NCMB. Para naman sa organizations ng Singapore is meron tayong Law Society Arbitration Scheme. Pangalawa is Law Society Mediation Scheme. And pangatlo is Law Society Neutral Evaluation and Determination Scheme. Para naman sa disputes na hinahawakan ng Philippines is yung ang OADR ay nag-a-address ng various disputes including family, commercial, labor, and community disputes. The barangay justice system is a significant component for resolving minor disputes at the community level. So, sa OADR, merong family disputes, commercial disputes, labor disputes, and community disputes. Meron din tayong barangay justice system na re-resolve ng mga minor disputes sa mga community level or sa mga barangay. Kaya nga barangay justice system. Singapore naman, they handle disputes in areas like businesses, employment, family, consumer issues, property, intellectual property, insurance, and maritime conflicts through faster, flexible alternatives to court. So, yun. Medyo same lang din talaga. Sa methods naman, dun tayo medyo pumarehas pero medyo may kakaiba pa rin kasi sa Philippines meron tayong arbitration, mediation, conciliation, mediation arbitration, early neutral evaluation, mini trial at court annex mediation. Para naman sa Singapore, meron tayong arbitration, mediation, neutral evaluation, and neutral determination. So, ang pinagkaiba lang nito sa methods is sa Philippines ay meron tayong combination ng 2, while dun sa Singapore is 4 lang, tapos sila yung parang mga main na ginagamit lang din tulad sa Pilipinas. So for training, the OADR conducts training programs for mediators and arbitrators and establishes accreditation standards. It also provides resources for practitioners in the field. So dito sa Pilipinas, ginagastusan din yung mga mediators and arbitrators kasi sila yung kailangan experience sila and especially skillful pagdating dun sa bagay na yun. So mahirap na isasalang ka sa mga disputes tapos hindi mo naman expert yung yung field na yun. So for Singapore naman, ADR training includes mediation and arbitration courses to equip professionals with conflict resolution resolution skills offered by institutions like SMC and SIAC, along with certification and for accreditation. So dito naman sa Singapore is ganun din, meron din silang training center. Dito kan sinabi dito yung mismong kung saan mismo sila nagtitraining dun sa SMC at SIAC. Yung SMC is yung Singapore Mediation Center, tapos yung isa is SIAC or yung Singapore International Mediation Center. So meron din silang training center. Para naman sa cost, ADR is typically more accessible and cost effective, especially at the barangay level where services are often provided for free or at minimal cost. So sa Pilipinas, hindi siya masyadong magastos kasi minsan free or maliit lang yung kailangan mong bayaran para ma-arrange yung isang dispute. Para naman sa Singapore, meron silang nag-start around 900 to 400 Singaporean dollars yung per dispute. It's nagre-range from 10,000 to over 100,000 depending sa case. So medyo siguro hindi ko rin sure kung medyo pricey na siya para sa kanila or mababa pa rin. Pero sa pag kinonvert yung pera sa atin, medyo parang mas mahal yung kanila. So that's all for this report. Sana may nintindihan kayo. Medyo magulo ba yung explanation ko, pero thank you for listening, and that's all for today.